Good morning, good afternoon. Hello, everyone. We are so happy to have you with us today. My name is Linda Williams. I am a community outreach and training manager with Consumer Action, and I would like to thank you for joining us for today's event on estate planning for healthcare, finances, and more during the pandemic. Our guest speaker is David Godfrey. He's a senior attorney for the American Bar Association Commission on Law and Aging. I will formally introduce you to David a little later, but first, I need to tell you that today's webinar is part of a series of webinars that Consumer Action will be hosting in response to that dreaded COVID-19 crisis. So mark your calendars for several upcoming events. Circle September the 9th for a webinar on tracking COVID-19 economic devastation, where we will kind of take a look at how the pandemic has thrust us into a recession in recognition of the National Domestic Violence Awareness Month. Circle October the 6th for a webinar on the impact of COVID-19 on domestic violence and financial abuse. And for the month of September, circle November 17th for a great, fantastic webinar that we have coming up on the impact of COVID-19 on the mental health of children and how to protect children's privacy because they are online more learning, and since they're out of school, they're playing more games. So we need to learn how to protect their privacy. Also, Consumer Action is celebrating its 49th anniversary, and for this event, we're going virtual. So circle September the 29th and 30th on your calendar, and be sure to join us for all of these exciting events. Now, the Consumer Action's work on the COVID-19 Crisis Education project is made possible by a grant from Wells Fargo. So on behalf of the entire staff at Consumer Action, I would like to thank Wells Fargo for its support and its continued support. So before we get into the webinar, I have a few housekeeping tips for you as we advance through the feature presentation. You can use your question function to ask your questions. My coworker Nelson Santiago will be monitoring your questions, and at the end of the webinar, he will present your questions to our fabulous guest speaker. If you're on Twitter, you can tweet your questions on Twitter. Our organization's handle is at Consumer Action, and you can use the hashtag C8webinar. Now, the webinar is being recorded. All handouts will be placed in the Dropbox and made available to you after the webinar. We have created a fantastic new fact sheet on estate planning, so please go to our website at www.consumer-action.org at the end of the webinar and download a copy of the fact sheet. And once you do, be sure to share it with your clients, your coworkers, families, church members, everyone. At the end of the webinar, we want to hear from you. So you will receive a survey. Please complete the survey before signing off the webinar. Now, before I go over the agenda for today's events, let me tell you a little bit about Consumer Action. Consumer Action is a national nonprofit advocacy and education organization following in the footsteps of Ralph Nader, has served consumers since 1971. At Consumer Action, we enjoy an extremely rich history. In September 1975, we waged a protest against supermarkets selling low-income consumers dented food cans. As you know, it is the leading cause of botulism. Later that year in November, we conducted the famous demonstration. That's right, where we had a parade of cars in front of the San Francisco's posh British Motors to protest the resale of defective automobiles. In the 80s, we began to empower consumers with free, easy to read survey guides and fact sheets about everyday pocket date issues. Today, we enjoy a national reputation for creating multilingual consumer education materials in the area of credit, banking, privacy, insurance, and telecommunication. That's right. All of those kitchen table pocketbook issues that impact you, your families, your neighbors, and the communities that you serve. So please go to our website and download a copy of our new fact sheet on estate planning. All you need to do is type in estate planning in the box under search, and voila, it will come up. Now we are a 50 501c3 organization. We're supported by grants and donations like any other nonprofit. So for the low cost of $25, you can become a member of Consumer Action and help us continue to do some of the great work that we are doing. At the end of the presentation, there will be information if you're interested in donating, how you can donate. So let's take a look at the agenda. We're going to open up this webinar the way that we open up all of our face-to-face trainings with one of our most popular games. How much do you know? By testing your knowledge with that popular game. Following the game, we will move into our feature presentation, estate planning. Following the presentation, we want to hear from you. This is where I will turn it over to Nelson and we will take your questions. Then we will wrap up and launch the survey. So let's get started with how much do you know? Let's launch the first poll question, please. Okay, the number of Americans that have a will or other type of estate planning documents have decreased since nearly 20% since 2015, 17. Is that true or is that correct? The number of Americans that have wills or other type of estate planning document has decreased by nearly 25% since 2017. Is that true or is that false? Come on. All right, let's look at the results. Okay, 81% of you are saying that it's true, and 19% are saying that it's false. 81%, you are exactly correct. That is true. Let's move on to the next question. A growing number of people say that they lack the knowledge and resources to establish a will. Is that true or is that false? Come on now. A growing number of people say that they lack the knowledge and resources to establish a will. Is that true or is that false? Don't overthink it. Okay, one more second. Let's look at the results. 95% of you think it's true, while 5% think it's false. Well, 95%, you are correct. That is absolutely true. Let's move on to the next question. Okay, here we go. Here we go. Less than half of people making 80,000 or more have any estate planning documents. Come on now. Less than half of people making 80,000 or more have any estate planning documents. Is that true or is that false? One more second. Okay, let's look at the results. Okay, 86% thinks it's true, 14% says it's false. Actually, it's true. Go ahead, 86%. Let's launch the last poll question. Despite its importance, a recent survey found that 1 in 5 people do not know what an advanced health care directive is. Is that true or is that false? Despite its importance, a recent survey found that 1 in 5 people do not know what an advanced healthcare directive is. Is that true or is that false? Okay, let's close the poll. What are the results? 97% is saying it's true, 3% is saying it's false. That is absolutely true. So as we move into this next segment, that's one of the things that you will learn is what a healthcare directive is. Thank you so much for your participation. We sincerely appreciate it. So let's move on. Before I introduce our guest speaker, let me tell you a little bit about him. David Godfrey is a senior attorney to the ABA Commission on Law and Aging in Washington, D.C. Prior to joining the commission, he was responsible for the elder law programming at Access to Justice Foundation in Kentucky. He earned his BA with honors from Roland College in Winter Park, Florida, and his JD cum laude from the University of Louisville School of Law in Kentucky. He served on the board of the National Academy of elder law attorneys and was named a fellow in the Academy in 2019. Now, before I introduce Mr. Godfrey, would you like to know at least one fun fact about him? I hear everybody saying, yes, yes, yes. Okay, you twisted my arm, I'll tell you. Well, he loves to travel. And he's been to 48 states and check this out, 16 countries. 16 countries. I would love to learn more about those countries, but let's learn a little bit more about estate planning. So let me start by turning this presentation over to Mr. Godfrey. Okay, Mr. Godfrey, take it away.
Thank you. Again, my name is David Godfrey, and it's my pleasure to be here this afternoon to talk about topics that are near and dear to my heart. This is work that I've been doing for about 21 years now, and one person at a time, one day at a time, we make a difference in the lives of older adults. So, as this year has shown, bad things happen, illnesses, injuries, disasters. When we started off the year, I was planning a conference with a theme of Vision 2020, a play on words for 2020 vision, and had no idea how that vision would change in such a rapid period of time. But as things happen, there's still a need to make healthcare decisions, to manage money, and to deal with the inevitable of death and taxes. And we'll talk about those issues and how they enter into the lives of everyday people as we move forward this morning. I like to call this planning for incapacity or death. It's much easier for most people to think about planning for incapacity. What will happen if if I get sick, or for some reason I'm not able to make healthcare decisions or manage my money. We see a lot of unnecessary guardianship and conservatorships that could be avoided with very basic, simple planning, things that we'll give you some advice and some ideas on how to do and how to guide others to the process of getting done today. And there's a lot of confusion and difficulties, a lot of emotional distress in families over healthcare decisions that a little bit of basic planning and some heartfelt discussions can make a lot easier. Starting point we want to talk about is develop and talk about and document healthcare values. I'm going to tell a story here. When I was a legal aid attorney, my first house call as a volunteer for hospice was on an older couple. The husband was a hospice patient. Arrived, sat down to talk to them. The husband was not engaging well and wasn't talking, and the wife was engaging really well. So I decided that I'd help her first. And I turned to her and I said, let's talk about your healthcare wishes. And she told me who her first choice and second choice were to make healthcare decisions. And she told me what her values were. She said, I've lived a long and joyful life, and when my time has come, my time has come. Turn off the machines, take out the tubes, give me lots of morphine, and let me go quietly. And we prepared her paperwork, put it in writing, got it signed and notarized. And I turned to the husband and I said, now, what are your wishes? And his answer was, I don't need one of those things. And I, well, what do you mean? And the hands on a hospice patient connected to an oxygen feed. Obviously, he has some serious healthcare issues. He said, I'm counting on a miracle. Some researcher someplace is going to find a cure for what's killing me, and that's what I want. So I don't need those forms. And I actually shifted gears and I said, well, then let's put your wishes in writing, that you want everything done that's possible to do to give that researcher an extra hour to come up with a cure. And we did that. And shortly after that, he was enrolled in a clinical trial program. I think he was patient number 2 in some experimental treatment. And he did what he wanted to do. But the end result of all of that is it really drove home to me as a young lawyer, as someone starting out in the field, that the healthcare your person receives is what the person should want, what's important to them. When I asked him, how come you were enrolled in hospice? He said, that's because that's what they told me I should do. Nobody asked. You were the first person that asked me, what should I do? Or what do I want to do? They were telling me what I should do or what was best for me. And healthcare decisions are very personal and they're very values based. And the only way that we can assure that the people get the health care that they want and not get health care that they don't want is to empower people to think about their health care values, to put them in writing, and to have conversations with their loved ones and their health care providers. Last time I saw my general practitioner, I had the conversation with her of, this is who I am, this is what's important to me, this is what I would like you to do as as I continue to age, and what I really don't want. And she very much appreciated it. She was very happy in making copious notes in my chart that I took the time to talk to her about it. It's important to get a couple of things in writing. You want to name a healthcare agent, and there's a little parentheses there. Even if it's the same as the default, 45 states have a statute that says if you can't make your healthcare decisions, who can? But even if you're going to name that exact same person, putting it in writing allows your healthcare providers in a moment of crisis to focus on practicing medicine and not on trying to figure out what the law says and who the family members are, because those default statutes generally defer back to immediate family first, work their way out through the family tree, and then decide who's going to be able to make healthcare decisions. If you can hand them something in writing that says this is the person that can make healthcare decisions for this patient, it makes their life so much easier. It's important to name a backup agent. Agents get sick, they die, they move away, they're unavailable, they don't answer their phone. If they're like me, I don't turn my cell phone on some days. So you need a backup agent if at all possible. We leave specific directions on some big picture issues. The traditional advanced healthcare directive is a form called a living will, which really leaves directions about very end of life, artificially provided nutrition or hydration, primarily feeding tubes, life prolonging care. And those are very specific to very late stage illness or disastrous injury. And sometimes we leave big picture directions, but just as important or more important, and I started out talking about it, is documenting and talking with family and healthcare providers about what the person's values are. There are some values tools that are out there, some development tools. These are just 4 of probably a dozen different ones that are available. The Conversation Project has a whole series of starter kit handbooks. They're available for free off of their website. Just Google the Conversation Project. Great workbooks, very well written. 5 Wishes is probably the oldest of the bunch. It's been around for a good number of years. Again, you can find them online. There's a small charge for their publications to cover their cost of preparing and printing. Prepare for Your Care is based out of California, but they now have versions that work in virtually every state. They're more medically oriented. It was developed in a collaboration between a medical school and a law school in the San Francisco area. And the Go Wish cards, and there's also an online version called the Go Wish game, it turns it into a sorting game, sort of a logic game. Why do I do different tools? Different tools work for different people. I love the Conversation Project's workbooks, but I've never been able to get myself past about page 2. 5 Wishes has a strong spiritual component in it, and that really connects for some individuals. For other individuals, it doesn't. They get to that point in it, and they go, well, this doesn't really connect to my values, but there are other tools that are available. I like the Go Wish cards. My brain categorizes and sorts things, and that's the way the Go Wish system works, is it categorizes and sorts values and beliefs. So try a variety of things. Try what works for you, and those are just really good and useful. In giving somebody, putting it in writing, we have a publication on our website, Giving Someone Your Power of Attorney for Healthcare, a multi-state guide and form that works in 45 states and the District of Columbia. There are 5 states that have very specific language requirements that a standardized form doesn't work in. Off of our website, which is americanbar.org /aging And then if you go into resources and research, you'll be able to find links to all of these. There are links to state-specific healthcare directive forms for all 50 states. They all have very specific signing requirements. When you sign them, generally you need 2 disinterested witnesses, people who aren't family members, people who aren't healthcare providers, people who aren't paying for your care, people who won't inherit from you in the event of your death. It's generally the limitation on witnesses and or a notary, but follow the directions in there because those requirements do vary somewhat from state to state. We recommend that you revisit advanced healthcare directives, who you've named as an agent and what the values or directions are that you've put in writing at least once every decade. Anytime there's a change in marital status, marriage or divorce, death of an immediate family member or loved one, diagnosis with a major injury or illness, or a change in domicile anytime you move. The rules do vary from state to state. After my parents retired, they had a summer place in the north and they lived in the southeast. They had 2 sets of directives because the 2 states that they had homes in had very different laws and rules. And in order to make it work, they had 2 different sets of directions. So when they moved, they needed to revisit this. And they moved back and forth every year for a good number of years. Next most important thing is keeping the bills paid. When we look at the canary in the coal mine in older age, unpaid bills and undeposited income are frequently the first sign that someone's experiencing a change in memory or cognitive ability. This year, the experience of 2020 has also brought about a major change. And I wrote this a couple of months ago, and I was thinking March, April, and May, I didn't enter a bank. Since the end of February, I've not entered a bank, and I've only used an ATM twice. A lot of things have changed this year, stresses that have happened. I've got neighbors that because of their age and their health condition have barely left the building in the last since February. So banking has changed, but it's necessary to make sure that we continue to keep the bills paid. Step number 1, put it on autopilot. The vast majority of Americans that are working, their income is now on direct deposit. It's mandatory on most pensions. It's now mandatory with Social Security. If you don't set up direct deposit with Social Security, they will set up an account for you and send you a debit card. You can set this up for automatic periodic distributions from defined contribution plans, IRAs, 401ks, plans like that. It won't capture everything. It doesn't capture small business income or farms. I'm renting a garage parking space from one of my neighbors. It doesn't capture that. And I paid her in June for the next 6 months, and that check hasn't cleared yet. I know she has difficulty getting out. She hasn't had a chance to get it to the bank yet. So it doesn't catch everything, but it catches most of it. Back in my legal aid days, I went out on house calls from time to time, and sometimes it was to sort out someone's desk. And I found 6 months worth of income checks, of pension and Social Security checks sitting there in a stack on people's desks that they hadn't gotten to the bank. At the same time, their account was overdrawn and bills weren't being paid. So putting their income on direct deposit is really a first step and something that we pretty universally encourage people to do. Set things up on automatic payment, recurring bills that are paid directly from a bank account or charged to a credit card. A reminder is sent to the person, and then unless an objection is filed, the bill is paid automatically. We do recommend that these be monitored to make sure that the amount that's being billed is paid and that the things that need to be paid are actually being paid. Occasionally things change, especially if you're charging to a credit card, because credit cards expire on a regular basis. Credit cards can be set up to be paid automatically. And again, it won't cover everything, but it'll cover most of it. You do need email, online access. Read a news report over the weekend. About half of households in the United States don't have strong enough online access to view the webinar that you're viewing and listen to the sound at the same time. So there is still a digital divide. But if that's available, these are great tools. people need help setting it up. They need help working through the first few months, and they need help when they have a question or an issue that comes up. My first encounter with automatic payment of utility bills was my parents. They came home from lunch one day and the lights had been turned off. And my father looked around and checked things, and he called the electric company. And the electric company said, "Well, the bill hasn't been paid." And he looked at my mother and said, "Did you pay the electric bill?" "Oh, yeah, that came a long time ago. I paid it." And they sent me another bill, so I just ran it through the shredder. That was the moment that it really came home to my father that mom was no longer able to manage the household accounts. She was losing track of recording income that was coming in, and she was losing track of being able to pay the bills. The canary in the coal mine effect hit there. And when he went to straighten things out with the power company, they set him up on automatic payment, and that worked forever, the rest of their lives, to make sure that they weren't going to experience again having the lights turned off on them. We also suggest making sure that somebody else can sign on a bank account, and there are a couple of ways that this can be done. The most common one is you add a name to the bank account, and the default for most banks on this is to make it a joint account. There are a couple of cautions on this. A joint account creates a presumption of ownership of everybody whose name is on the account. And in a lot of cases, in the majority of cases, it creates an inheritance rights, not in every state and not on every account form, but quite often it creates an inheritance right that whoever lives the longest owns all the money in that account, subject to somebody challenging them on that. And for people of modest means, this can sometimes result in drastic changes in what their intended estate plan or inheritance plans were. By creating an ownership right in the account, if something goes wrong with one of those joint account holders' lives, if they get sued, if they have a judgment against them, if they file a divorce, they have tax liens or bankruptcy, the accounts can be frozen while the courts sort out whose money is in this account and is this person responsible for it, and if so, are the assets in this account subject to claims by other parties. So there is a caution on joint accounts. Authorized signers are another way of doing this. If you think of a corporate or a business account, the business owns the account. The people that are signing on it are just authorized to do business on that account. They don't own the assets in it. They don't have a right to inherit it. The challenge with authorized signers on bank accounts is most banks treat them as commercial accounts or business accounts, and the service fees can be rather high. I do hear reports of some banks that waive the fees on these, as they do on a lot of bank accounts, especially for older adults. But a lot of banks treat these as commercial accounts and charge service fees on them. You may also be able to authorize a signer on a bank account using a power of attorney. If you're going about doing it that way, we do recommend taking the power of attorney document to the bank today, asking them to review it, to put it on file, to recognize it as valid. Um, Back in my legal aid days, I would actually take the client and the power of attorney document and go sit in the bank's office and sign it and have them notarize it and put a copy of it in their file. It's kind of hard for them to come back later and go, "Well, we're not sure whether this person signed this and whether they knew what they were doing." And not all banks would do that. But we had a couple of banks that would, and it helped to simplify it. There are a handful of states that are passing new power of attorney laws that also facilitate this, and we'll talk about that briefly in a couple more slides. Some general cautions: trust the person you name on the bank account. If you wouldn't trust them to hand them all the cash in your pocket, all your credit cards, the keys to your house, and the keys to your car, and walk away and leave them for 6 months and not be worried about when you came back, would it all be there? Don't name them. There are some risk factors for agents, for joint account holders and agents on bank accounts, people who have physical and mental health challenges, people who are experiencing challenges in their family life, people who are being sued. uh, our higher risk agents. And ask them for a universal heads up. The conversation I had with a family member of mine is, you don't have to share with me the details of your personal life, but if something goes wrong, and I gave the laundry list of things that might happen, give us a heads up so we can make changes in the account so that we don't end up tying up mom and dad's accounts in the process of what really was intended to try to expedite things. Power of attorney. We recommend that people name an agent on a power of attorney. Now, the power of attorney is the document. It's a document that appoints an agent. The agent can also be known as an attorney in fact. Um, and this needs to be done before it needs to be done, meaning that you need to have capacity to do this. And capacity is, you need to understand that you're naming someone and authorizing them to transact business on your behalf, that the decisions and choices that they make are binding on you. You can't change you can change your mind, but you can't change what they've done or haven't done. And then in general terms, what you're authorizing them to do, what you're giving them the authority to do on your behalf. Again, on selecting an agent, if you have any doubts, don't name the person. Power of attorney is very state law specific, and it is an area of the law that evolves somewhat rapidly. Probably 3 or 4 states in an average year will enact some type of a change or amendment in their power of attorney law. Some states do it much more frequently than that. I'm licensed in a small Midwestern state that makes a change in their power of attorney law once every 20 years or so. They did a major reform last year, effective July 1st, which was the first major reform that they had done since about 1980. Just a couple of minor amendments in between. Ideally, work with an attorney in your state. Creating a power of attorney, naming an agent is a very strong issue. A power of attorney is generally effective when it's signed. Unless it says otherwise on the document, the person can start using it immediately. And it ends when you die. There are some statutory exceptions of things that the agent on a power of attorney can do after the death of the person, but generally it ends there. Or when it's revoked, powers of attorney are revocable as long as the person has the ability to say, I don't want you to do that anymore. They can revoke it. The authority that's granted is defined within the terms of the document and sometimes and limited by state law. There are a handful of things that you can't delegate the authority to do. You can't delegate the authority to someone else to get married for you. Well, there's a couple of states that make an exception to that. To vote for you. And there are usually some other fairly far out there limitations, but you can't use a power of attorney for someone to vote. And there's only 3 states, I think it is, where you can use a power of attorney to ask somebody else to commit to a marriage contract for you. Those are really interesting exceptions to find. If you're a non-lawyer, you can do this yourself. There are some states have statutory forms. Read it. If you understand it, if you're comfortable with it and you want to do it, it's your choice. For others, we encourage you to connect with legal aid, pro bono, clinical programs, or to provide statutory forms. I would encourage community action entities, the network, to work with local bar associations, legal aid programs, and pro bono programs to set up clinical programs to help low and moderate income families complete a basic power of attorney, an advanced healthcare directive, some type of a basic estate plan. It's an ideal volunteer project for a lawyer, for a pro bono lawyer, because it has a defined amount of work. You know when it's going to start, and when you're finished, you're finished. It's not an open-ended or ongoing commitment for the lawyer. Um, a lot of these done in the legal aid or pro bono forum are 2 to 3 hours of the lawyer's time, and it's finished. They will put some limits on what they can do. Complex estate planning, generally, you're not going to find done on a pro bono basis. Be careful as non-lawyers to not engage in the unauthorized practice of law. The biggest risk factor there is if you start answering questions that are applying the law to the facts that the client has. That's the unauthorized practice of law, and that'll get the lawyers and the Bar Association angry with you. Long-term care needs. If you're alive at 65, there's a 69% chance of needing either in-home or inpatient care assistance in your lifetime. Statistically, the research tells us that 59% of us will receive unpaid in-home care from family or friends. Family and friends are the largest provider of long-term care in the United States, and aren't really very recognized for, and frequently it's not planned for. So one of the things we'd like to do is urge people to think about, if you need help, who might be able to help, and what can be done to facilitate that? Can you do things to make it possible for a family member, a loved one, a friend to provide assistance that's needed in home on a long-term care basis? About 35% of us will need at least limited amount of paid inpatient care, and we'll talk briefly about how that goes about getting paid for. Planning to pay for long-term care. Medicare, which is the health insurance coverage for virtually all older adults and persons with long-term permanent disabilities, pays for limited home health care services and limited inpatient long-term care services. On home health care services, it's very limited in quantity, and it's very focused in what they can do and what they can't do. The limitation is usually maybe weekly visits, sometimes bi-weekly visits. But in duration, as long as it's medically necessary, the healthcare providers can continue to authorize it for an extended period of time. So a visiting nurse to come out and check on someone and help them with medication and necessary checks can be done for an extended period of time. But it's very limited in quantity. This is not going to be 2 or 3 hours every day, 5 days a week. It's going to be a skilled nursing visit by a qualified nurse for a relatively short period of time. And it's going to be limited in the number of times per week that it can be done. But that can go on for an extended period of time. Medicare pays for limited inpatient long-term care. Generally, they pay the first 100% of the first 20 days, and the amount in excess of a very high deductible for days 21 through 100. And then Medicare, by definition, stops paying. Medicare supplemental plans pay that copay or deductible for days 80 through 100 or 81 through 100. Most of them do, not all of them, but most of them do. And some Medicare supplemental plans and some Medicare Advantage plans will add to this core Medicare home care or inpatient long-term care skilled nursing facility benefit. Uh, they don't have to, but they will. I was really surprised when my mother was sick. Her Medicare plan, she was running out of her 100 days in her Medicare plan, actually conferred with the nursing home doctors and the physical and occupational therapists and said, if we pay for another 10 days, she stands a much better chance of going home and not ending up back in the hospital and back in the nursing home. So we'll pay for an extra 10 days. I don't think they were contractually obligated to do it, but it made medical sense. And it was good to see the logic that they put into it and the reason that they went ahead and did it that way. Long-term care insurance, private insurance to pay for long-term care for skilled nursing facilities and for paid in-home care. Only about 10% of Americans have, and it's a shrinking market. There are more policies ending each year than new policies are being written. It's been a very challenging market for the insurance companies. And at this point, if you have it, great. If you're able to keep it, great. Make sure that you have sufficient coverage so it'll actually pay a meaningful benefit. We see 20-year-old long-term care insurance policies that pay $100 a day. And if you're in a major metropolitan area in the United States, you may find that skilled nursing facility care is $200, $300, $400 a day, $500 a day. So sometimes we see the policies and the payment limits are so low that they're no longer sufficient to do what was originally intended. But that is a vastly shrinking market. Medicaid is the largest payer of nursing home care, and Medicaid is a joint federal and state needs-based program to pay for medical care for people with an economic and medical need. Between 70 and 80% of the funding for Medicaid comes from the federal government, so 20, 30%. It varies from state to state depending on some complex formulas in the law. Of the funding for this is provided by each state. Because the state has a significant financial investment in Medicaid, the states are given a lot of flexibility in the rules. So knowing the Medicaid rules in one state is just simply knowing the Medicaid rules in one state. Where I live, I'm within a 15-minute drive of 3 different jurisdictions, 3 different states, 3 different sets of rules, which can make it challenging to try to figure out what the rules are and where's the care available. There are some federal guarantees, minimums and maximums that are set in federal law. If you're married for nursing home care, Medicaid, you can own a house. There are some equity limits on homes. Generally, they only pop up in they only become a factor in high value housing markets. A car, and the state can define the car. In most states, a car is a car. It doesn't matter whether it's a 20-year-old car or a brand new one. I saw a file one time where the family went out and bought a new Bentley. It was a car. And someplace between $25,284 and $126,420 in other assets. Those dollar amounts change each year. And each state has some flexibility in defining what counts as other assets. So these will vary from state to state of what gets counted and what doesn't get counted. Generally, things that are considered an investment or can easily be converted to cash count as other assets, and that's a very generalization. And all states have complex rules on how this works. Just like tax planning, there are asset planning options available for Medicaid. If that's something that you're interested in doing, or you have someone who thinks that's something that they want to get involved with, I do recommend that they work with an attorney who has experience in this area, working on Medicaid asset planning in the location where the person is at. There are a lot of non-attorney planners engaged in this. And I just have one comment on the non-attorney planners is malpractice insurance. If you work with an attorney who does this, they should have malpractice insurance. If they make a mistake, they should be able to make you whole. If you work with someone who got an outside certification, a lot of states treat this as an unregulated area. They may or may not have liability insurance, and if they make a mistake, it may be your problem with little recourse back against them. By federal law, all gifts made within 5 years of the date of a Medicaid application for long-term care may result in ineligibility. So when someone is on in life or has experienced an illness, an injury, and the need for long-term care is likely within 5 years, you need to be really careful and really cautious about gifts. The states do vary significantly in how they apply the rule, but it's a federal law, and it's out there across the board. I'm going to talk for just a couple of minutes about death. If you die intestate, not on the interstate, but intestate means without a will or estate plan, your state legislature has passed one for you. Every state has some rules on this. They do vary significantly from state to state. The generality on these, the most common one is half goes to the spouse, half in equal shares to the children. The second most common version is all to the spouse. And then when the spouse dies, it goes to the children. If there is no spouse or children, they go to the nearest living relatives based on a priority in the statute. I actually practiced in a state that had what we call the laughing heir statute. If my third cousin Butch, who's a plumber in Detroit, was the last surviving family member, he'd inherited it all and he could laugh all the way to the bank. I've seen him twice in 40 years. Wonderful young man, really talented guy. But that varies from state to state, how far out you go into it. But the bottom line on intestate succession is often what happens is not what the person would want. And some simple plans can allow someone to put into writing what their plans are, what they would want to have happen to their money and property at the time of their death. Which is best, a will or a trust? This is a debate. You can ask that question in a room full of lawyers and keep them busy for days debating and arguing about it. And the weasel lawyerly answer is, well, it depends. And it depends on a long list of factors. To some extent, what state you're in. Estate and probate laws vary significantly from state to state. In some states, it's a lot easier to do a will. In some states, a will is the last thing you want to do, and you always want to do a trust. It varies with how complex the assets are, what the person owns are. Businesses, rental property, farms become really complex, require a lot of management, and are going to lean in one direction or the other. Depends on what you want to have happen to it. Outright gifts to adults are fairly simple. Gifts to children starts to become issues where you're dealing with trusts. Gifts to charity become more complex and frequently get involved with trusts. It also varies based on family dynamics. Are people going to be able to agree? Are they going to fight? Are they going to get along? Trusts are better if there's difficult family dynamics. Wills, if they're simple, if the family's in agreement. One of the things that can make a will work well is a family that gets along well and that there's not disagreement. So when is a will best? When the state has simple, efficient, and low-cost probate processes. Um, this is a frequent debate on professional listservs, and some states will come back with 90 days start to finish. We're in and out, and the filing fees are a couple of $100 to probate a will, so why bother doing anything else? And then the next person will come back and say, in the state they're in, the probate the fee to the probate court is based on a percentage of the value of the estate, and it can be thousands of dollars. So they always do trusts so that they don't have to go through the probate process. So it depends on what state you're in and how simple, efficient, and what the costs are in that process. A will in and of itself has little value until it's gone through probate. And the states are creating some minor exceptions for that, but for the most part, a will in and of itself on its face has no value until a court has looked at it and said, this is a valid document saying who gets what out of this, and supervises the process of making sure that liens, debts, and obligations are paid, and that the remainder of the estate is distributed in accordance with the will. So a will always has to go through probate. Simple assets that require little management work better with it. Are easier for a will, and if there are a few probate assets, I'll use my parents as an example because they wouldn't take my legal advice even if I offered it, and they lived in a state that I didn't practice in. The only thing that was left that was not the only probate estate left in their estate was their car, and they lived on in a state that had an express lane for cars, so it was fairly easy to do, and a low risk of challenges. When is a trust going to work better? States with complex, time-consuming, or expensive probate processes. In some states, we're seeing nearly 100% of all planned estates passing through trusts because of the way their probate process works. Although when we're looking at half of adults not having any estate plan in place, that still means that half of the estates are ending up going through that extensive process, because an intestate estate or an estate with a will is going to go through probate. When you own a lot of assets or assets that require management, if you do a trust, make sure you're willing to do the extra work. There's nothing so tragic as setting down to settle an estate, seeing that someone 2 years ago spent $5,000 to have an estate planning trust established, and there's no assets title to it. Everything's still in the name of the grantor. They didn't bother to transfer any of the assets. They haven't managed the assets in the name of the trust. People waste money creating the documents if they're not going to go ahead and transfer title assets in the name of the trust and properly manage it. Um, Trusts also work better if there's a likelihood of a challenge to the estate plan. When you create a trust, you do it today and you actually transfer the assets into it. It's harder to come back a year from now, 5 years from now, 20 years from now, and say, when he did this, he didn't know what he was doing. It's much easier on a will to say, when he signed this, he didn't know what he was doing because he wouldn't have done this if he knew what he was doing. The courts generally, a trust is harder to bust than a will is. Whether you're doing probate on an intestate estate, an estate with a will, or you're doing a trust, one of the first things you need to do is assure that debts and taxes are paid. Um, and there's some priority for those. If there's not enough money, the funeral, the lawyer, and the tax person generally get paid first, and get paid in full, and then the rest of them, there's formulas for how the money is divvied up. Most estate planning trusts stop when the assets are distributed. These aren't trusts that exist in perpetuity, although in some states they actually go through a formal process of terminating or closing the trust. In other states it simply remains empty. I have two of them in a southeastern state that I'm trustee of that don't have a penny in them, and in that state's laws, those just exist forever. Somebody could go back and put assets into them if they wanted to, but it wouldn't make sense to do so. A lot of what we own are non-probate assets, assets that are owned jointly with a right of survivorship. This is all, but not all, most, correct me, most, but not all, jointly owned real estate. A home that has both names on it quite frequently is owned jointly with right of survivorship. How you create that varies from state to state. Some states require very specific language in the deed to create that. Other states is simply if a home is titled as spouses, it's presumed that it's owned jointly with a right of survivorship. Most, but not all, financial accounts with more than one name on them. And to know how this works, you really need to look at the bank account and how it's turned. But most joint financial accounts are non-probate assets. They pass by operation of law. There's no need for probate on them. There's nothing that needs to be done. My name was joint with my father on his checking account. And when I was done settling out his estate, I just simply walked into his bank, somebody that's helped sponsoring this series, and said, hi, this was Dad's checking account. My name is on it. All of his bills and everything has been paid, and I've split everything with my brothers and sisters. It's time to close the account out. And there was no question. They didn't ask for anything. I could close the account without any questions. Most likely those assets are still subject to taxes or to creditors' claims. The process for that varies, and the process for transferring out non-probate assets varies, but frequently there's really not much that needs to be done. Ask or consult an attorney. My parents lived in a state that I didn't practice in. When my father passed away, I went and paid his attorney a consulting fee, about $1,500, to explain to me how the process worked in that state, to help me with a couple of details of the way that particular state's laws worked. And among other things, he pointed out to me that the state they were in had an express lane for motor vehicles. We were able to transfer the car out of Dad's name without needing to go through the probate process. In the state that I had practiced in, we didn't have that, and we did a lot of waiver of probate, small estate probates, where we had a 20-year-old car rusting away in the backyard, that because it was still titled in the name of the deceased, the junkyard wouldn't haul it away for scrap until we got title to it. And the only way to get title to it was to get the court to order, yes, it's okay. Somebody owns this and they can they can send it off to the junkyard. Non-titled personal property. The biggest things that we see people fighting over are jewelry, guns, um, some furniture and artwork. Jewelry and guns are the two that pop up most often because they're easy to pick up and take away. They disappear when someone dies. Um, so those are non-titled property. Technically, they're part of the estate. As a practical matter, if people want to fight about them and argue about them, there was a legendary probate case in a court in the Midwest of a family that spent $40,000 in attorney's fees and 2 days and a whole week in court fighting over the contents of the kitchen. $2,000 worth of junk in the kitchen, and they spent $50,000 in court time and attorney's fees fighting over who was going to get pots and pans and dishes out of the kitchen. Usually it's just worked out amongst the folks, and because those are not titled assets. There are a lot of payable on death or transferable on death items and beneficiaries. A lot of financial accounts allow you to name a beneficiary. These are bank accounts, brokerage accounts, credit union accounts that allow you to name a beneficiary. This is not a joint owner. It's the accounts in my name and my name only, and when I die, I'd like the account payable to or transferable to, or the beneficiary to be. And those pass by operation of law. Usually you need to present a copy of a death certificate, but there's pretty minimal things, and they're generally non-probate assets in most states. Retirement accounts, if you're not leaving your retirement account to a spouse, it requires consent of the spouse, and there are special procedures and processes that have to be followed with that. And if they're not followed precisely, the spouse can object and come back and claim their share of the account. Life insurance pays to the named beneficiary, and unless the beneficiary is the estate of the deceased, it pays to the named beneficiary. And a will or a trust doesn't override that named beneficiary. And there's litigation on this every year where someone thinks, I wrote a will and that changed who gets my life insurance, but they didn't change the beneficiary and the life insurance policy. Retirement accounts and pensions, the same thing happens. And we recommend that people periodically review these, because sometimes the paperwork is lost, or it's improperly processed, or you simply forgot to do it. And there was a case that popped up recently of an ex-spouse from 30 years before that got the big surprise when someone died, and all of a sudden the spouse gets the inheritance. In the case, it was life insurance and a pension, and it was a significant amount of money. Hence, there was litigation, and the courts ruled, no, there's a process for this, and if you don't follow the process, the outcome is whatever's on the paper overrides. Things to do before someone dies. Make sure that someone knows where the essential documents are at. If they're locked in a safe deposit box that nobody has access to, it's not going to do you a lot of good. Finding the will 10 or 15 or 20 years after the person dies in the back of their underwear drawer doesn't do you any good. Gather usernames and passwords. Know who the named executor or trustee is. And if there is no plan, talk about who's going to serve as administrator or executor. Try to avoid fighting over it. Pre-plan, or at a minimum, know what the person's funeral wishes are. Research consistently shows that families that don't pre-plan spend more money than they would have if they had. In most states, you can pre-plan and not prepay. In most states, pre-planning does not guarantee that the wishes will be honored. We had a guest speaker last fall who's an estate planning attorney and a funeral director who's advocating around the country for states to adopt laws where pre-planned funerals, especially that have been pre-planned and prepaid, can't be broken without getting a court order showing that there's a miscarriage of justice by honoring the wishes of the person. Gather a list of persons who need to be contacted. What to do when someone dies. Take time to grieve. Recognize that no two people are impacted the same way. For a lot of people, a death is a very, very stressful time, and you need to be mindful of that and a little bit forgiving. And safeguard assets. I have gone and waited in the house for the locksmith to show up and change the locks while the surviving spouse went to make funeral arrangements because they were afraid that a family member who had keys to the house was going to come in and take the coin collection and the guns. Waited for the locksmith to change the locks. So sometimes it's necessary to safeguard assets, and this is usually jewelry and other small high value items that are easily walked away with. Notify credit cards. Missed this on my father's estate 2 weeks after he died. He bought something from Amazon. Somebody ordered something from Amazon and his credit card number was saved in the browser on the computer in the house, and they just charged it to the card on file. If I'd called his credit card company and canceled the account, they would have gotten a notice of, sorry, this is not a valid account number. Please put in one that's good. Gather everything you can about the person's financial life. Call Social Security and pensions. With Social Security and pensions, the presumption is that the last check that you receive, they're going to take back and you can't spend. Talk to Social Security and they can look at the payment date and the date of death, and they can tell you whether the last deposit is going to be taken back out again. But the presumption is don't spend it until you're sure. And the same thing on pensions. Ask for extra copies of the death certificates. You'll be surprised how many you need. If the estate is insolvent, if the person owes more money than the assets that they own, I recommend turning it over to an attorney. Estate planning, should you do it yourself or hire an attorney? The answer is very state specific, but the general rule on this is one simple oversight where you saved $1,000 by not paying an attorney up front can cost thousands of dollars in extra costs on down the road after the death and trying to get things sorted out. Probate and settling the estate, the vast majority of probates are done by family members. It depends on, is it solvent or insolvent? If it's insolvent, I recommend always hiring an attorney. How well planned is it? How complicated are the assets? How well everyone gets along? Like I did on my father's estate, I urge you to at least consult with an attorney to assure that you're not missing something. And remember, probate 50 years after the fact is much more complicated. We see a lot of family homes that are 50 years later and still in the name of the deceased. So some action steps, put it in writing. Who you want to have make healthcare decisions and talk about your healthcare values with your family. If you haven't already done so, set up automatic direct deposit and automatic payment on recurring bills like utilities. Make a list of your usernames and passwords. I'm behind on this one. And talk to a lawyer in your state about estate planning and a power of attorney. I've run a little longer than I should have, and I'm sure we've got questions backed up.
Okay, well, David, thank you for a great, fantastic presentation. There's a lot of information, and the PowerPoint slides will be placed in the Dropbox later, so you would have those questions. So now we want to hear from you. Nelson, are you out there? Do you have any questions for David?
Yes, we do have a few questions. David, a couple of people actually asked, what if somebody doesn't have children or living family members? What type of will or what type of things would they have to do? What needs to be done?
Okay. The first thing that becomes critically important is finding someone that you trust to make healthcare decisions and help you manage finances while you're still alive. And if you don't have immediate family, then that becomes a matter of finding either a trusted friend or a professional in the community. There are they're qualified healthcare managers and money managers that for a fee will serve those roles. We see some good community-based organizations that use volunteers to fulfill those roles for people who are unable to identify anyone. Because taking care of things while you're alive, I think, is more important than worrying about what happens after you're not. So far as basic estate planning, think about who you'd want to benefit from what's left when you're gone. I have no children. Our estate plan will provide whatever's left over between some educational institutions that have made a significant difference in our lives, to hoping that they can use the money as scholarships to make the difference in the lives of students coming on down the road.
Great, thank you. Somebody else asked, what are your feelings on web-based solutions for wills and trusts?
These have emerged since I've moved off into the research and training side. So I don't have a lot of firsthand experience with them, although I did probate some wills where people had written them themselves using using software packages that were available 20 years ago. They frequently are not, there are a lot of details and a lot of state-specific quirks in the law that are easy to overlook in an assisted do-it-yourself or a do-it-yourself an online platform. Those are usually overcomeable. The reaction that we get from attorneys that are probating them is, it would have been cheaper for them to pay me a little bit more to do this right the first time than it is to fix the mistakes that we find after the fact. How many of those are probated without question or problem, or estates that are settled and cleared without questions or problems? I really don't know. That's an area that somebody needs to do some research on it, but it's certainly an emerging area. And I'll make a bold statement that some of the lawyers will hate me for. A do-it-yourself will that's properly signed and executed so it's admissible in your state is better than no will at all.
Okay, thank you. We have another question. Someone's asking, for Medicaid, whose assets count? Is it joint bank accounts, homes with child parent on title? If parents are claimed as dependents, will assets of a child be looked at as assets? Do you know that, or is it not on point?
There's a lot of that is state specific, so it's hard to give a general answer. Because each state is given some flexibility in defining. For a married couple, generally they're going to count everything owned by the married couple in either name. And there are some exclusions and some exceptions to that and some state-specific things that are there. With dependent children, the rules get to be even more complex because it depends on the age of the children. If the children have long-term permanent disabilities, there are differing rules depending on when the on the disability determination, and those are questions that you really need to talk to an expert in that state, and also recognize, if like I am here, where I'm a mile from a state border, if I cross the river into the next state, the rules are different there.
Okay, thank you. And we also had a couple of questions that people asking about what happens to debt after your death.
Debt gets paid out of your estate. Most states have a hierarchy where the state gets paid first, taxes get paid first. So state and federal taxes, if there are any owed, get paid first. Funeral expenses get paid off, that generally get paid first. In most states, the lawyer gets paid as a priority. Then the rest of the debts get paid. If there's more debts than there are assets, then the state will have a formula for determining different classes of creditors and how much they get. I actually have a former law clerk of mine who specializes in probating insolvent estates where the debts exceed the assets. It's kind of a specialized area of practice, and it's what Richard does.
Excellent, thank you. We have someone's asking if you can leave assets to family members or friends who are not in the U.S. and are not U.S. citizens, and how would you ensure that those individuals actually receive the assets? Do you assign an agent to deliver these, or something like that?
There are some That's a complex area of the law, and one where I would recommend consulting with an attorney who does a lot of international estate planning. There are some federal restrictions on inheritances outside of the US, and I think they actually vary slightly depending on where the person is at in the world. The process of assuring that they receive it is actually a two-part. One is we can assure on this end that the check is written or the transfer is made. The challenge is making sure on the other end where the money is being, or the money or property is being received, that they actually receive it. And another complicated area that pops up there is disabled beneficiaries that live outside of the country, and trying to make sure that the inheritance doesn't disqualify them for means tested benefits, which can be a challenge. And those are, I'm on a listserv for a national professional organization, and they actually have questions that pop up from time to time, and they have a couple of members that live outside the United States that consult on transfers in Europe.
Okay, thank you. We do another question, actually very pertinent now. How are people handling notarization or witness signatures remotely during this COVID era?
That witnessing and notarization rules or statutes, laws are done on a state-by-state basis. Most states have issued some type of at least temporary emergency orders, executive orders on it, and they vary widely from state to state. Some states are recognizing a remote notarization, where you email me the document, I turn on my webcam, we record a Zoom meeting while you explain the document to me, I sign it, and then I scan it and PDF it and email it back, and then the notary is able to notarize that, and they have to keep the copy of the recording and other documentation, and that's valid. In some states, the remote signing or remote notarizations are only good until 90 days after the end of the declared emergency. I have a friend who practices in the Midwest, and they've been doing all their signings in the office with a plexiglass shield in the middle of the conference table, and the witnesses standing outside an open door in the hallway and shuffling people in and out, so there's only a couple of people in the room at any time, because in the state they're in, 90 days after the end of the declared period of emergency, they'd have to re-sign and re-notarize re-sign, witness, and notarize everything. So they've been working around that. It's been a real challenge for folks that are in residential placements that have been on lockdown, where you've not been able to get witnesses and notaries in and out. Some of the facilities have facilitated that by allowing staff members to serve as notaries and other residents in the facility to serve as witnesses. In some states, on some documents, staff members of a healthcare facility can't serve as a notary. And so that's been an additional challenge, but that's been a huge challenge this year. And I think an area of the law that we'll continue to see changes over the next 4 or 5 years as a result of the experience we've been through.
Great, thank you. And then I guess since we're going over now, I'll just ask one more question here, and then I'll want to let listeners know, people who are tuned in, that we will try to get your responses. David has said that he'll help us get some answers to any of the questions we don't get to today. So, but for now, if I could ask the last one, when something doesn't go quite as you planned, somebody's asking, what suggestions do you have on how to get healthcare providers, financial institutions, et cetera, to recognize documents? She says that in a case that she's, in a family's case, they've had a lot of trouble with their mother's documents, both the healthcare power of attorney and the general financial power of attorney.
can be a real challenge. On financial powers of attorney, the Uniform Power of Attorney Act, which is a model law. It's not the law that any state actually follows, but it's a model law for states to look at when they're amending or making changes to their power of attorney law. Actually has a provision in it that financial institutions that are obligated to do business with the client are obligated to do business with the power of attorney if it meets certain requirements, unless they believe that there's exploitation or abuse going on. And if they fail to do so, there's a court action brought to force them to honor it. If they lose, they're responsible for the cost of bringing the action. The last time I checked, there were about 8 or 10 states that had adopted provisions along that line. The first one was California. It was the first place I ever read that. Beyond that, it can be a huge challenge. In some states, it can be really difficult to get a financial power of attorney honored if the banks simply decide they don't want to. It can be really difficult, short of going to court for a guardianship or conservatorship action, sometimes to get access to that. Healthcare powers of attorney, my experience with getting healthcare powers of attorney honored, unless there's a problem with the way the form was created, drafted, signed, usually what's happening is the healthcare providers are afraid that they're going to get sued by somebody, that there's a conflict going on or disagreement and argument going on between family members, and the healthcare providers will try to resolve that so that they don't get sued. And if they don't think that they can resolve that, they will defer to go see the judge and get a court order and come back and tell us who can make the healthcare decisions or what healthcare decisions are going to be made. It's kind of that's frequently when we see problems in that. That's usually the dynamic of what's happening. Ultimately, we see some guardianship and conservatorship actions as a result of power of attorney that can't be honored for whatever reason. Maybe just the banks are being difficult, or there's conflict going on between family members, and the banks and healthcare providers are setting back, going, we don't want to play referee in this, let a judge decide, and then come back and see us. Sorry about going over.
No, that's perfectly fine, and I'm sure the audience appreciates it. Thank you. And also, if folks have additional questions, you can also email Linda, and hopefully we can get some answers to those. So thank you very much, David, for taking the time to answer these.
Thank you. Take care.
Thank you, Nelson. Please join us once again in thanking David for a fantastic presentation. Again, his PowerPoint deck will be placed in the Dropbox. Thanks again for hanging in there with us. Please complete the survey before you sign off, and we look forward to welcome you back on September the 9th for our webinar on tracking the economic devastation of COVID-19. Until then, please stay safe, and we'll see you on September the 9th. Goodbye.